Good evening, Captain Retired Matt Edwards here. I'm going to be doing my weekly observation post Facebook Live update broadcast, I call it. And today is the 80th anniversary of D-Day, so I might as well mention that. I haven't been looking it up much, even though I've seen a few things on YouTube. It is, all the old people from World War II are getting pretty old. Mortality is claiming them. Now, this week I had a bunch of conversations and stuff with the Canadian Forces and the Veterans Ombudsman. So I'll start off with going through my first post for today because I got my sights turned on them a little bit. Okay, number one, might do a column, I said. That's what I call the pieces I write. Not that I get paid for them or anything, but I try to make things a bit more interesting than just stating facts. On the Canadian Forces or the Office of the Veterans Ombudsman or both. I wanted to do my homework, so I made a spreadsheet that showed what they have done since 1998. Now, that's not the Canadian Forces Ombudsman I'm talking about. Funny, the spreadsheet was just supposed to be a list, but I found out it's a link because I copied a link into it when I was making the spreadsheet, so it's more useful than I thought, I said. So if anybody wants to have a look at those reports, you can just go in, download my spreadsheet, click on the link in that, and you can go right to the spreadsheet, the report that the Canadian Forces Ombudsman did. So I'll add the 2006 program arrangement here, as I think that agreement might bind the Canadian Forces Ombudsman and the Office of the Veterans Ombudsman to work together. See, that's what's given me so much grief right now, is I'm trying to get both Canadian Forces and the Veterans Ombudsman to do a joint investigation into the Service Income Support Insurance Plan, Policy 901-102. Now, carrying on with my post to try to keep it simple tonight. Don't feel like going on too long, so hopefully I won't be here all night. Number two, the goal of my list was to examine whether they're following their mandate. I was thinking about the mandate, as it seems to me it's being abused so that they can refuse to investigate things that are not within their mandate, but here are some exceptions to that mandate for the Canadian Forces Ombudsman that causes confusion. A. 2003 unfair deductions from SISIP payments to former Canadian Forces members. Now, that was the title of the report. And then here is my quick and dirty analysis on that. Instead of saying former Canadian Forces members, I would have said veterans. However, the Office of the Veterans Ombudsman was not in existence yet, so I wouldn't play that card too hard. In fact, I would laud them for their attempt to help veterans. Too bad they did such a piss-poor job that would tarnish their reputation if people knew how bad it was. A lot of people, including myself, thought it was a good report. Now that I'm taking a closer look at it, I can see that it's not very good, and they might have been trying to gaslight people. Now, B, 2015, so 12 years went before the next one that I found umbrage with. Canadian Forces best position to determine public service priority hiring for releasing members. Now, this is what appears to me to be a turf war within the office, with the Office of the Veterans Ombudsman, which came into existence in 2007, I believe. As public service hiring after Canadian Forces service should be the Office of the Veterans Ombudsman, because you can't serve. So the Office of the Veterans Ombudsman is better situated to deal with that problem. Now, on that, I spoke to the Deputy Minister of Veterans Affairs, General Latinchuk, in 2018 about that, because of a technicality that people run into. There was 5 years to get a priority referral to a public service job, but a lot of times people weren't healed up enough to go back to work. So that was what the complaint was, like they should have more time. I told the general, well, all the public servants need to know is that they can exercise discretion and they can be flexible with the 5-year thing, instead of it being absolutely no past 5 years, they can just say, well, if they weren't ready until 6 years, we'll approve it. That's called discretion. They can exercise discretion in doing their job. C, 2016, simplifying the service delivery model for medically releasing members of the Canadian Armed Forces. Clearly, this is an Office of the Veterans Ombudsman issue, though a case might be made for the Canadian Forces member still being a member until medically released. Isn't what they're saying really reducing red tape? Now, on that point, I've been researching this stuff for a long time. When a person gets medical release, it's in accordance with the law, Queen's Regulation and Orders 15.01. And then they assign a classification to you after you go through what used to be called the Career Review Medical Board, and then it was called the Army Review Medical Employment Limitation Board. And then a board of 3 doctors reviews the other doctor's finding, and you had to be in excess or past the threshold on a medical category. So I went through 2 of these. I had one for when I had psoriasis, and my commanding officer thought it was nuts when they told me why. He asked me why I was having the Army Review Medical Employment Limitation Board. Said, but a doctor told me I had psoriasis and that he wouldn't have let me in the military if he had been the doctor doing the enrollment physical. Now, later, when I got documents through my Privacy Act request, I found out, my medical category was reduced from 2 to 3, and 3 was the threshold that you could still serve as a logistics officer, which I was. So, in fact, there was no reason for the Army Review Medical Employment Limitation Board, and then there wouldn't have been my commanding officer ask me a question and thinking that I lied to him. Incompetence. It's all over the place. Sounds like my dog is coming down to join me. Now, D, 2016 report, part-time soldiers with full-time injuries, a systemic review of Canada's primary reserve force and operational stress injuries. The only comment I made about that is injuries. That means after service to me, so the Office of the Veterans Ombudsman should be the one looking after this report, not the Canadian Forces Ombudsman. E, 2016. Gee, they're pretty busy in 2016. This is the 3rd one that I mentioned, and there's one more to come. 2016, determining service attribution for medically releasing Canadian members. Now, I've noted that report before, and I think that this is, again, the turf war between the Canadian Forces and the Veterans Affairs Canada, and the Veterans Ombudsman and the Canadian Forces Ombudsman. I said clearly the Office of the Veterans Ombudsman. Then I put maybe. Because so many things overlap, a case can be made for each of these. However, I do agree, at least in part, either the Veterans Affairs Canada or the Canadian Forces can determine service attribution. Examples of this already exist. Number 1, SISIP Policy 901-102, Section 41A3. This requires a person to be hurt on duty, so Manulife has to determine whether a person was hurt on duty, or a reservist cannot get their SISIP through Manulife. They only administer the test, or whatever the fuck they use, for the Government of Canada. 2, Reserve Force Compensation, which is Compensation and Benefit Instruction 210.72, does it for those still serving while they see if they can return to service or if they have the medical release. So this is akin to workers' compensation, sort of. So I think it's 20 days a month, Class A pay to people who are hurt, until they either medical release or they get back to service, and then the compensation and benefit pay stops. 3, the refund of SISIP premiums for those who get hurt in service. Now, as far as I know, this is on paper. I don't know of anybody who said, when I got medical release and I was hurt in service, I got a payment from the Canadian Forces for the refund of my SISIP premiums. Never came across it once. Plus, even though I didn't write it here in my post today, I think the whole thing is out to lunch for saying that, okay? The only reason that I could see them saying that is that they might be trying to link it to workers' compensation. So basically, if I'm right, they're trying to say that, like workers' comp, where the employer pays 100% of the premiums, they're saying that they'll give you your money back, so they end up paying 100% of the premiums. The only thing that I can think of, that's the only thing that makes sense. Now, again, 2016 in point F. Maybe I should say foxtrot because of the phonetic alphabet, but this is not a military report. No, I'm out of the military now. So F, 2016, a systemic review of compensation options for ill and injured reserve force. Report, I think, report in 2016, or the fifth one? Fourth. This one is a strange one, as I just mentioned above. It is about disability, but while still serving. Perhaps like the pension being paid in addition to a person's pay for service after the year 2000. But compensation provided under CBI 21072 is a replacement of income. Oh, income replacement benefit. It just struck me because they like to throw that word around. While they're still serving, unlike SISIP and income replacement benefit. You see, SISIP isn't like the public services insurance. The public services insurance, you can collect insurance before you get released from your civilian employment. For example, I was on leave without pay for 3 years, and I was getting Sun Life long-term disability insurance before I was actually released from the public service. But in order to get the Army's long-term disability insurance, you have to actually be medically released, and you had to have no right to return to your service. I think that is ridiculous, because what happens if someone was rehabilitated? Shouldn't they have a position to go back to? Anyway, moving on, G. And I must have got tired of writing because I never put any comment on it, but it says understanding retirement and disability benefits. Now, I did have an idea that this could be something I might drag up before and talk about tonight, because I think, as a preview, that they wrote a very biased report, something that I've already commented a bit on yesterday in a different post, but basically a lot of, if not everything they said, was crap. So, turning to the Office of the Veterans Ombudsman in point number 3. A. The Veteran Bill of Rights is very prominent. Why? I don't think this comes up much at all. To the veteran, I mean, to anybody, do you know anybody that knows about or cares about the Canadian Veterans Bill of Rights? But I looked it up, took a screenshot, posted it to this post. B. As I mentioned in the preamble, maybe it's not a preamble, but whatever, the program arrangement signed by the Department of National Defence and Veterans Affairs Canada might bind the Canadian Forces and the Veterans Ombudsman to work together on issues of common ground, such as SISIP and income replacement benefit. After all, 2 departments went through the trouble of signing what appears to be a legally binding document. Now, I used appears to be a legally binding document because I don't think it's very legally binding. If you tried to say it was like a contract, then you would say, where is the consideration? If you were trying to say this is a binding agreement, it's between, the Canadian Forces and Veterans Affairs, but there's no Manulife signature. And on paper, Manulife is the party that makes the actual payment. Now, I know, and anybody that listens to me, if they agree with me, knows that Manulife merely acts on behalf of the government. So any payment being made by Manulife is really being paid through Manulife, which is what the affidavit of settlement of the Manus class action said. Okay. C. I'll probably do what I did for the Canadian Forces Ombudsman with a spreadsheet later. D. I put this in quotes, so I'm presuming as me quoting some source. To identify and review emerging and systemic issues related to programs and services provided by or administered by the department or by third parties on the department's behalf that impact negatively on a client. Now, I said, doesn't this sound like SISIP should be investigated? Because or by a third party on the department's behalf sounds exactly like either D&D, SISIP Financial Services, or Manulife, administering the income replacement benefit on behalf of Veterans Affairs Canada, as they only top up SISIP with Veterans Affairs Canada's version of SISIP. Now, I ran that idea by the Office of the Veterans Ombudsman later today after I did this post, and they more or less agreed with me. I hope they'll look into, can they look into it? That's all I'm looking for, really. I can't guarantee an outcome. I can't guarantee an investigation, but I don't want to be lied to or told this is not within our mandate. Not if you look at that part of their mandate, which is the third bullet point in their actual mandate. And if you look at something as a program that's being administered on behalf of Veterans Affairs, now somebody might try to say, well, SISIP is not being administered on behalf of Veterans Affairs Canada. Then we'd say, well, how come it makes up 83.33% of the income replacement benefit? How come the Canada Gazette in 2006 said that they were going to top up the existing SISIP income replacement benefit with the Veterans Affairs Canada income replacement benefit when applicable? So basically, I don't want to be told bullshit. Okay? So 4, this post might be getting too long. This is my curse, okay? I start into something, I mean to keep it really simple and short, and then lo and behold, it's hours later. For example, I called the Office of Veterans Ombudsman today. I meant to be on the phone for 5 minutes. 60 minutes later, I was saying, listen, I know I'm talking too much. I'll let you go. Have a good day. Okay, but I did mention this to the lady, and that's probably why the phone call took so long. Okay, this post might be getting a bit long, so I'll mention one other possible point for a column that I might do. Though posting it here might be enough. The SISIP hot potato. Then I made a bunch of bullet points. 1982, Treasury Board Secretariat assumes control, presumably from Maritime Life, but maybe the Department of National Defense as well. We have the right to know about the facts of this action. The 1st of March 1990, the Chief of Defense Staff takes effective control of SISIP Policy 901-102. Both Maritime Life and the Chief of Defense Staff Representative signed the alleged agreement, and I put in brackets. No consideration was paid, so this might be void. 3rd bullet point, sometime after 1990, but before 2019, Treasury Board Secretary takes control of SISIP again. 4th bullet point, 2006. Department of National Defense and Veterans Affairs Canada signed a program arrangement linking the two programs so that no one should try to avoid handling the hot potato on the basis of jurisdiction or mandate. That was me getting a shot in against them goddamn ombudsman for not taking this load off my shoulders and saying, yes, bye, Matt, thanks for your call, and we'll look into it. Because that's not what they're doing. Instead of that, they'll argue with me for hours instead of just saying, you know, thanks. We'll check it out. 1st of April 2019, the Department of National Defense takes control of SISIP again. Related, 2003, the Canadian Forces Ombudsman reports on the unfair SISIP clawback, so the Canadian Forces Ombudsman was investigating SISIP, proving that it is within their mandate. Related, 2013, OVO actuary report talks about SISIP a lot. I counted it up by doing a word search. I think it was over 100 times. Related, the Office of the Auditor General report in the file of 2012 talks about duplication of rehabilitation. Now, I put in here income replacement benefit because the rehabilitation as a condition of payment, the benefit is income replacement benefit. The benefit isn't rehabilitation. So then going on, I said the hot potato problem seems to be about holding people accountable or avoiding holding people liable for their actions to me. Editorial note, let me know if I should bother commenting on the pictures. Because when I do these posts, I try to put all the facts that I spout off to prove that they are facts and not just opinions and garbage. But then I'm thinking, well, do anybody read the post? Do anybody read the comments? So I said here, I do this to make specific notes, the pictures that I post as evidence, and the facts that I've read about. Am I wasting my time? Are the picture comments helpful? Do you see what I'm doing, making sure that I cannot be accused of making stuff up, creating alternative facts, etc.? Then I said, oh my fucking God, I never learned. 45-minute call to the Office of the Veterans Ombudsman when I met for a 5-minute call concerning the idea I had about why SISIP falls within our mandate. Then I copied off what I had up above. But I put a footnote by the word behalf. And then I said, if you look at SISIP long-term disability as a program and service provided or administered by the department or by third parties on the department's behalf, with either A, the Department of National Defense being a third party, I personally disagree with this as this is another government department, or B, manually being a third party administering SISIP on behalf of Veterans Affairs Canada, then the complaint I'm making falls within the Veterans Ombudsman mandate. 2. I mentioned medical releases need to be deemed officially to Veterans Affairs Canada clients. Now, this is a general comment, not about that particular mandate thing. After all, they designed the income replacement benefit to integrate with SISIP, which is paid automatically after medical release. See the program arrangement that I'm always talking about. Now, you see, the thing is, and I thought of this while I was talking to the lady, Stephanie, I said, the thing is, about all of this stuff is that I'm asking you guys and the Canadian Forces Ombudsman to look into the very program that they designed to save money when they get rid of the pension. So, under the old system, the pension was deducted from SISIP. Then Dennis Manouche sued the government, and they won, and it stopped. But I said, if you look into the program, the Service Income Support Insurance Plan, and you see that what I'm saying is true, then they can't do what they wanted to do and change the direction of the savings. So before it was Veterans Affairs Canada being taken into account by the Department of National Defense, and after 2006 it was the exact opposite. The Department of National Defense payment was being taken into account under the Veterans Affairs payment, and therefore the government still saved. But I said on that point, first of all, the government never put into the Veterans Wellbeing Act regulations, they didn't put a clawback term for the Service Income Support Insurance Plan. So it's illegal. They're doing it without any lawful jurisdiction. Secondly, I said, maybe it's because they didn't have a law to back them up. After the Manouche case in May of 2012, they also published a compensation directive, and they deemed the Service Income Support Insurance Plan, Policy 901 and 102, to be a clawback for the income replacement benefit. Now, I got news for them. A policy put out by the department is not law. They weren't elected. They can't make law. Okay, they might treat it as a law, but it's not legally binding. I said there's also the problem of the provincial law saying that insurance cannot be touched by a creditor. Then there's the National Defense Act, Section 39.3, that says non-public property is not allowed to be touched, and SISIP was created under Section 39 of the National Defense Act, so therefore it's non-public property. So now I've just spouted out 4 different reasons why Veterans Affairs Canada can't take SISIP into account. Now, I never thought of this when I talked to her, and I mention this in case people are actually listening to me. But according to the Manouche judge, SISIP is an indemnity for lost income. Now, if that is true, then Veterans Affairs Canada ought to be using Section 25 of the Pension Act to reduce the pension for those people getting SISIP or income replacement benefit. Because that's the rule. The compensation principle says you're not allowed to get compensated twice for the same injury. But we know that the government's not doing it. So is this deliberate, avoiding, something that they could legally be doing? Because let's face it, I told her in the common law, if you get hit by a car, you're walking down the sidewalk, you get hit by a car, you sue in tort. You happen to be in the Canadian Forces. You're off duty, and you're walking along in your civilian clothes on the sidewalk, a car smacks into you, you become disabled. You end up getting medical release, you end up getting SISIP, but you sue the people who hurt you to get damages to make you whole. Well, the insurance company, which damages are paid usually by an insurance company, you have to have insurance to operate a motor vehicle. Well, they say, this person is getting compensated by the Service Income Support Insurance Plan. So therefore, we don't have to pay damages. Then the judge turns around, well, excuse me, you go fuck yourself. Because this is a non-indemnity and contributory insurance that is purchased for peace of mind. And the rule is that three things are not allowed to be taken off of damages: insurance, charity, and pensions. Now, they started first with the insurance exception rule. Then they added pensions later because they're much the same as insurance. And charity got through in there too because they said that they wouldn't want the wellspring of charity to dry up. If the only person that was saving, if someone gave someone money out of the goodness of their heart, and then somebody who had to pay damages decided that because the person got money from somebody else because of that charity, then they didn't have to pay damages, then the person that's giving the gift, the charity, wouldn't bother because it's not really helping the person who got injured. It's a very good point, and I keep meaning to post about it, but this actually came true. There was a case where a person was on welfare. They got hurt. They sued for damages. When they went to get their damages, the people paying the damages tried to argue that the welfare should be deducted. The judge said quite properly that charity cannot be deducted from damages. So what happened? Provincial governments wrote laws that said if you get damages and you're on welfare, you have to pay the welfare people back. So that risk that the common law, the judges said that would happen, the wellspring of charity drying up, society got to be pricks and decided to claw back the money. Now, I had a conversation with my member of the House of Assembly staff on this. I was trying to get them to look into stuff that's on the provincial level instead of the federal level. The assistant to the member of the House of Assembly said to me, well, if someone's on welfare, social assistance, and then they get $1 million in damages, don't you think that they'd have to pay the social insurance back, social assistance back? I said, no. No, they don't. Because the damages are to replace the injury to their body, and that is a capital payment, not an income payment. So you should not be taking that payment into account and making them pay back their damages, pay back damages to the welfare people, because then they're not made whole from the damages payment, you stupid fuckers. It's like people think that, and I mean, I don't think this happens a lot. I think that's why Pension Act Section 25 exists. I don't think that happens a lot. But the people that are worried about paying money out for nothing, because that's what they say, they think this money is a waste or causing a windfall for the person. But think about it. In order to get the pension, you had to have become disabled in military service. In order to get tort damages, you had to have been injured by somebody else, and they had to have an obligation to pay you back. You're not getting money for nothing. You're getting money to repay the legal debt that's owed to you because somebody hurt you. So it's awful conniving. It's awful evil for people to try to think of ways to fuck over the person who's already become disabled. Just tell it like it is. Now, going up to the second post I made, because I did make another post, and let's see, I've got a lot of pictures that pops up as a post themselves when I put them in. Okay. Second post of the day, I said, I'll try something new here, a singular focus. I mentioned this to the Office of the Veterans Ombudsman lady I spoke to this morning. Dual clients. Okay? Number one, because I like to be logical, I put things in numbered lists a lot. Number one, the Canada Gazette in April 2006 made a public policy to integrate the Service Income Support Insurance Plan, long-term disability with Veterans Affairs Canada Income Replacement Benefit. No one can argue with that. Whether they should have done it or not, that's why I said it's illegal and immoral and unethical. 2, Veterans Affairs Canada and DND and SISIP Financial Services, they signed a program arrangement in 2006, and they updated it in 2012 for integration of SISIP and Income Replacement Benefit. 3, Veterans Affairs Canada published the VPPM5, that's Veterans Policies and Procedures Manual 5 in 2006, showing that SISIP and VAC clients were created by medical release from the Canadian Forces. Now here's what brought that up, this thought. When I was talking to the lady, Stephanie, now she grew up with Dennis Manu, she tells me, so she seems pretty good to talk to, for one thing. I was telling her about myself. I said, listen, I got medical release and I have nothing from back. But in 2003, there was a workers' compensation board case called Martin, Supreme Court of Canada, 2003. And it was about pain sufferers. And the people that had pain injuries weren't treated the same as other disabled people, so it was ruled to be discrimination. But an important point in that case was the guy was denied access to the workers' compensation system, and the Supreme Court said that it's a benefit to be part of a system. And yet, here I am on the outside looking in, so I don't see this as being any different. So I told her that, I made a thing in my post. I suggested a possible public policy change to be made. And it's not a very big stretch. Every person who becomes medically released, the government should deem them to be hurt in service. Then they would get automatic approval to the Veterans Affairs Department. They wouldn't be left on the outside looking in, and it wouldn't cost the government very much money because 70 to 75% of people that are medically released are hurt in service anyway. Okay? So really, it would streamline the process. It would save them money on administration. It would make our lives more, better. It's not a good grammar, but it'll be easier on us. And it would be a good public policy decision to do that. It would be a win-win situation. Now, I don't think that will be accepted, because remember the 2016 Canadian Forces Ombudsman report where they said that the Canadian Forces should be the one who looks into service attribution? Well, that's what I'm talking about, see? But in my expert opinion, I hope I don't turn off people by calling myself an expert. The generally accepted definition of an expert is someone who has spent 10,000 hours studying a subject. I'm pretty sure I put in way more than 10,000 hours into this shit. Now, the thing is that they have been operating this way anyway. Okay, they might not have announced it, but from 2006 to 2019, that's when they changed it. As far as I know, they changed it, because before that, they had this phrase about earnings loss benefit, income replacement benefit, and you were entitled to that if you had been hurt primarily in service. Now, some people got their knickers in a knot about that term, and they went back to the old rule, I guess you could call it, that in order to get Veterans Affairs payments, services, and whatever, you had to be hurt in service. Now, to say that someone's going to get income replacement benefit because they were hurt primarily in service, that's splitting hairs. Really. Because, again, expert opinion here, if you wanted to go to court and sue somebody in tort, the judge has to be considered 51% that you are right, and then you win your case. It's called the balance of probabilities. Now, if you use the phrase primarily, hurt primarily in service, that's 51% that you were hurt in service. But you see, I think that the government these days uses a much higher standard, like scientific proof that you were hurt in service, because they want to see some kind of medical evidence that you were hurt in service, when really it should be operating just like a regular case before the judges. They should be just trying to say, is this evidence believable? You know, the CF98 form, I believe a lot of people follow those. That's nothing but a narrative, a story, but a lot of times it will back up someone to get them proof that they were hurt in service. There might be hospital records, there might be other stuff. But this is what I'm saying about, if you deemed anybody who's medically released to be hurt in service, it makes everything easier. I would say it's almost exactly like workers' compensation. Because if you get hurt on the job, they don't, you know, you're on the job, it's automatically approved. That's the way it's supposed to be. Now, the caveat there is that over the years, they have become really picky about that, because the employers want to have lower premiums, so they try to be picky about who gets workers' comp. I went to my doctor and I was talking to him about my disability claim. I said I might put in a workers' compensation claim. Oh my God, you shouldn't go there. They're bastards to work with. Doesn't matter if it's bastards to work with, because if you got hurt in service, that's your right to sue is gone. You have no right but to apply for workers' compensation. Now, the doctor was falling into the same trap that Dennis Manouche fell into. When I was talking to Dennis years ago, he's not my Facebook friend anymore, but he was for a while. I was talking to him and he told me he doesn't get SISIP anymore. Now think about how strange that is. The fellow who led the class action, the class plaintiff, and SISIP was taking his pension act pension into account. And then a few years after the case, and he's no longer getting what he won in court. Now that makes me wonder how many other people are like that. Now he said to me, which he thinks makes sense, why do I want to deal with them pricks? I'm getting 90% from Veterans Affairs, so I don't have to get it split between two different payments. I get it all from Veterans Affairs, and it's a lot easier than dealing with them manually son of a bitches. Yeah, but Dennis, you're entitled to both. What? I can't be entitled to both. How can you get 165%? Now, I'm paraphrasing. I might even be ad-libbing here a bit. But you see, if the income replacement benefit is a replacement for the Pension Act, then it's compensation for your injury. It's meant to make you whole. The Service Income Support Insurance Plan is a non-indemnity payment. It doesn't compensate for anything, and therefore you are entitled to get it in addition to any form of compensation. So it's not a matter of either or. You have to get both. Now, this is the bottom line for how come this shit is happening to us. Because the government, I don't know if they're doing it on purpose or not, but they're trying to say that the SISIP policy indemnifies you or they compensate you for your lost income. Hey, hang on a bit. Am I getting compensated for my injury like a tort lawsuit, even though I bought the insurance and I paid the premiums? And I don't get all of my damages back. I'm only entitled to 75% of my pay? They can go fuck themselves. That's not how it works. Damages are paid by a stranger to a stranger that they hurt, and they're not paid to someone they know, usually. And SISIP is people you know because it's a contract of fucking insurance. Allegedly. So this gaslighting program that has been going on for a long time has people gaslighted into believing that A, you can't get more than 100% when that is false. That's not my opinion. I'm quoting a guy by the name of Mark Daniels, the president of the Canadian Life and Health Insurance Industry Association. He was speaking to a finance committee about long-term disability insurance. It was either 1997 or 2003. I had the picture. I didn't have the date attached to the picture. And he spelled out the fact that, you know, people who are getting insurance, long-term disability insurance and a contract, it depends on what the contract stipulates that you will get. So it could be 50% of your pay, it could be 60, 75, 90, or 120%, he said. Now, take that fact and put it with the damages award that was paid in the Andrews versus Grandin Toy Supreme Court of Canada case in 1978. The man was making $800 a month. When they were going to assess the quantum of damages, he was a quadriplegic after the automobile accident. Instead of multiplying whatever lifespan he had left by $800 a month, which was what he was making at the time he was injured, they said, well, you know, a person's career is not stagnant. They will get promotions in the future, so they use 50% more. They used $1,200 a month to calculate out his damages. So for all those people that think that you can't make more when you're disabled than you did when you were healthy, there's nothing but rubbish. You're not making it, first of all. Nobody who's disabled and cannot work is making money. What they're getting is, all depends on the money they get. If you get a Pension Act pension, you're not making money. You're getting compensated for your injury under the Pension Act, and it's paid in relation to your exchange of the right to sue in tort for the right to a pension. So it's the exact equivalent for civilian workers' compensation. If you get a new Veterans Charter, Canadian Forces Morale Officer, CFMWS, the new Veterans Charter, that replaced the pension, and it seems like, although I never focused on it much in the past, it seems like they think you exchanged the right to sue to get it. Now, if you exchange the right to sue to get something, then it's a tort lawsuit replacement. Now, if you have a tort lawsuit replacement, that means you can't sue the other people because you exchanged the right to sue to get the compensation. Well, Dennis Manouche sued the government for the SISIP payment. So therefore, it's not a tort lawsuit replacement. The income replacement benefit that is being paid under the new Veterans Charter, the Toth Federal Court 2019 case kind of proves that that's not exactly the same thing. Now I say that because they wiggled their way out of paying it for the Pension Act clawback, and they agreed to pay it in relation to a human rights abuse, which to me is nothing but bullshit, okay? So in the Manouche case, they twisted it to get it into a contract action when there is no contract. Why isn't there a contract, even though I sometimes let it slip accidentally that it's a contract? It's not a contract for real, because a contract must have some form of negotiation. Even if the only form of negotiation that you have is to get up out of the chair in an insurance office and walk away without signing. That might be the only form of control that you have about insurance, that you don't buy it. But the government took away the soldier's right to choose by making it a law in 1982 that you had to buy SISIP. So they passed the law under the National Defense Act, under the Queen's Regulation and Orders, which are regulatory law, and they passed 208.53 to require that your pay be deducted for the SISIP premium. So from 1969 to 1982, for a period of 13 years, they did it right. They allowed people to choose whether or not to buy the insurance. But in 1982, they violated the common law's principle in contract law that you ought to be able to pick and choose who you want to contract with. Whether they'll be held accountable for that one of these days, and I don't know how they would assess damages. I really don't. But they did do people wrong. You should not be forced into buying something that you didn't want to buy. Now, I'm getting tired of talking, so I'll mention one other thing. It's related to what I was just talking about. If you think about income replacement benefit, which is what I'm railing about a lot, that's a form of insurance. Where are the normal rules? Workers' compensation, SISIP, they had to have actuarial reserves put away to pay future claims, because that's how insurance works. You don't pay it out of just constant cash flow revenue. You have to have money put away because of cases that happened where companies went bankrupt and then there was no money left to pay the people that were on the insurance. Well, public pressure caused the governments to create laws to require actuarial reserves to be put away for claims. But the income replacement benefit has no actuarial reserves. So that's a problem. It's a problem because they're not following the same rules everybody else does. Then, moving on to something that's near and dear to my heart, not really, I'm just joking, taxes and statutory deductions. The government claims income replacement benefit is income. Well, that's false. It's being paid in relation to an injury in Canada's military service. It's supposed to be a tort lawsuit replacement. Now, tort lawsuits are about capital payments and not income. So therefore, it's a monthly capital payment, not a monthly income payment. And people might say, what's the difference? Well, the difference is capital is something you own, and income is something that adds to what you own. Okay? Income increases your wealth. A payment to replace something you lost doesn't increase your wealth. It is not income by definition. So if you look at the income replacement benefit paid by Veterans Affairs Canada, they do not take out Canada Pension Plan. They do not take out employment insurance. So while they pretend that this is income, they don't treat it like income for those statutory deductions. Now someone might say, well, Matt, what's the point of bringing that up? Well, they're not playing by the rules. The rules say if you get paid income that you have to do this and you have to do that. But when they come up with an expense that's related to those programs, because it's not so much just taking it off your check. If they take out Canada Pension Plan and they take out $100, they got to put another $100 with it of their own money. And then they have to put $200 in the bank for the Canada Pension Plan. If they take out $10 for employment insurance premiums, by law they had to put $14 with it, and then they had to put in $24 to Canada Revenue Agency, who will then forward it on to the employment insurance people. So basically, those two statutory deductions are an expense for the employer. So this is why they don't want it to be treated like income, except for taxes. So they want to tax it under Section 61F.1 of the Income Tax Act. Why did they choose that particular section of the Income Tax Act? Well, the Service Income Support Insurance Plan is Section 61F of the Income Tax Act. So because they copied SISIP, they copied the tax for SISIP as well. See? Now, I know I'm getting tired of talking about this, but I'll explain a couple of the problems about the integration of SISIP and the income replacement benefit before I finally hit the finish button here. Let me tell you how this is a fucked up system. SISIP has a cap of 2% on inflation. Veterans Affairs Canada used to have a 2% cap from 2006 to 16, but they ended the cap in 2016, and now it's fully indexed. You'd say, so what? What does one have to do with the other? Well, because these programs are integrated, 83.33% of the income replacement benefit stems from the SISIP program, which is capped at 2%. So Veterans Affairs Canada achieves a windfall in times of high inflation because almost 85% of the payment is being paid with a cap of 2%. That's a problem. Then there's the cost of living allowance exception rule. Under SISIP, now they don't do it, don't get me wrong, but on paper in the contract they have exceptions to the inflation factor to try to make themselves look good, I guess. So if you got $1,000 Canada pension plan, first year they take $1,000, the next year they got to take $1,000 until you die. They got to take $1,000 off because of the cost of living allowance exception for a clawback that's contained in Section 24B and 44B of the policy. Now I called up Manulife about this years ago when I discovered that they're doing it in my case. I said, listen, Christopher, fucker that I'm always dealing with there is Christopher Anderson, his name is. So listen, Christopher, how much are you taking out right now from my Canada pension plan? How much are you clawing back? 1,050 or something like that. 1,053 maybe. I said, well, I guess you're in violation of the contract, Section 44B, because it says that you cannot do that. Oh, the computer for the SISIP payment uses complex computations and algorithms and stuff. I said, hang the fuck on, Christopher. If it says in the policy that you cannot take anything more than what the original award is, and then I look at the original award and it was $1,017.94. Then I look at it and I ask you how much you're taking off now, and you tell me $1,050. That's not $1,017.94. So you're fucking breaking the contract. Yeah. A couple of weeks later, it occurred to me that the Reserve Force pension plan was being deducted in the same way. So when I called up and I asked, this time he tried to give me some bullshit and he tried to avoid the question. I said, listen, Christopher, that's not what I was asking you. You're launching into all this stuff here. I'm asking you a simple question. How much are you taking off right now at this moment for my Reserve Force pension plan? He told me, confronted with my direct question. He tells me, and then it's not the same amount that I was originally awarded. So I said, I guess you're breaking the contract with that too. Now, what would a normal person, a reasonable person, when confronted with the fact that they have been violating the contract on two different pensions and insurances I get, and then they're told they're doing it wrong, what do you think his answer would be? Wouldn't be what you expect. There's nothing you can do about it anyway, he said. You were part of the Dennis Manouche class action lawsuit, and there was a cost of living allowance rule settlement there, and therefore you are barred from doing anything about this anyway, he said. Huh? He said, yeah, you think so, do you, Christopher? I'll call the McInnes Cooper lawyers, and I'll discuss this issue with them, and I'll see if your interpretation of this is right. Because, by the way, I wasn't part of the Dennis Manouge class action. I don't get a pension act pension. Then I hung up. Then I called McKenna Cooper. I spoke to one of the lawyers that handled the case. I explained to him. Now, I've said this many times, so excuse me if I go through this again, and you might know about it. But I said, I consider myself an expert in these things, and I've been looking at this case that you guys handle for Dennis Manouge, and I never really saw a very clear explanation about what this extra issue was that you discovered during the case, and then you settled it with the class and settled it with the Crown. But my take on it is that, okay, if you got $2,000 SISIP and you got $1,000 pension act pension, and then you had $1,000 net payment, and the cost of living is capped at 2%, which would be $20, then the next year you will get $1,020. But this is what they were doing. But what they ought to have been doing is put the cost of living allowance 2% on $2,000, which would be $40, so that would be $2,040, and then you take away the pension of $1,000, and then you get a payment of $1,040. So the damages would be the difference between $1,040 and $1,020, and Bob's your uncle. That's exactly what it was, he said. Well, I said, it's nice that I could figure it out, but don't you think that you guys should have told the class exactly what the settlement was for? I wasn't part of the class action. But, on that topic, I said, Christopher Anderson of Manulife told me that I was barred from suing or doing anything about the cost of living allowance on this problem, and then I explained it was Section 24B of the policy, Section 44B of the policy, and that the clawback amount was supposed to be excluded by mutual agreement in the contract, and therefore they were in violation of the contract. And to the best of my knowledge, this wasn't addressed in your SISIP class action lawsuit settlement. And then he said, you're exactly right, that issue was not part of the class action. So now that was, I would say, 8 or 9 years ago. I'm not the only one that this is happening to. Now, I calculated out that it was about $560 or so, which is not the moon. But there might be thousands of people that this is happening to. And they are deliberately ignoring this part of the contract. Now, to give you an idea of how this fools people, I was talking to, I believe, the Public Service Superannuation Act administrators, Public Works Government Services, I think it's called. And I was explaining how the Canada Pension Plan clawback is illegal. Maybe I was talking to them about bridging being illegal. And then they said, well, at least she gets to keep the cost of living allowance exception. I said, well, you might think so because it says so on paper in these policies. But you know something? They don't actually do it. So when this happened, I called up Sun Life because I get insurance from where I work with CRA. I get Sun Life insurance. So I wanted to see if they were doing the exact same thing that Manulife was doing. So I called them up and I said, listen, guys, in the policy there it says that you're not going to touch the cost of living allowance. Do you touch the cost of living allowance? And the lady said, no, they don't. Now, I think I made a mistake. I simply asked her if they did it. And then, these people don't know everything about what they do. She probably looked into the policy, saw that it says they don't do it, and assumed that they don't do it. Like any reasonable person would do. But you know something? Later on, I got a statement from them, and it showed different years, and it showed the clawback amounts, and they were clawing back more each year for my public service pension because of the cost of living adjustment, which meant that they, too, were ignoring the exception. Now, see, this is the kind of stuff that makes you wonder, what are they smoking? If you're doing something wrong, like you're stealing money from disabled people, you ought to try to do it on the down low and not get them all riled up by finding out that they're breaking the contract in a very obvious way. And I know I want to shut up, but I'll mention this one point, because why I'm going after the Canadian Forces and the Veterans Ombudsman on SISIP is about clawbacks. Okay? The bottom line for all this stuff is the government's doing things it shouldn't be doing. Now, I said to the lady today, Stephanie, I said, listen, one of the biggest things that I'm trying to get you guys to look into is a thing that I call the double and triple dip clawbacks. So if you get the Canada Pension Plan, for example, and then the Canada Pension Plan, if you also get the Canadian Forces Superannuation Act, they claw back under the thing called bridging. So that's one clawback. So if your Canada Pension Plan was $1,000, then potentially you could lose $1,000 to a reduction in your Canadian Forces pension. Now, if you were medically released from the military and you're getting SISIP, well, they would have been the ones that forced you to get the Canada Pension Plan, first of all. So they would deduct $1,000 from your SISIP, long-term disability. So that's now $2,000 you've lost because of getting $1,000 in Canada Pension Plan. If you were hurt in service and you're getting the income replacement benefit, then they would take $1,000 into account, and Veterans Affairs would save $1,000. So you have the Canadian Forces pension saving $1,000 a month. You have the SISIP policy, the Department of National Defence saving $1,000 a month, and then you have Veterans Affairs Canada saving $1,000 a month. Now you got $1,000 a month from the Canada Pension Plan, so you take $3,000, take away $1,000 off, and you're down $2,000 a month because you got the fucking Canada Pension Plan. There's no way they can justify that. So I told her about the Canadian Life and Health Insurance Industry Association has a policy that private insurers, when they have this thing happen to them and they have two insurances wanting to claim the Canada Pension Plan, they split it 50-50, and the person doesn't end up losing more than they get paid in Canada Pension Plan, which solves the problem about the person who's disabled getting all riled up. In my case, I lost $2,550 a month because I got Canada Pension Plan. I got $1,000 a month in Canada Pension Plan, so I'm down $1,550 a month since 2015. Now, that's one thing. But the other kick in the nuts is that you get retroactive Canada Pension Plan. I got $13,351 fucking dollars. I had to pay $10,000 back to the public service pension. I had to pay $1,000 back to the reserve force pension plan. Now that's $11,000 out of the $13,000. Then SISIP wanted $13,350, and Sun Life wanted $13,350. Altogether, I ended up with debt assigned to me of $39,000 for getting $13,500. You can't justify that. You can't say, here's your bill for $26,000 because you got $13,000. If you had that choice, you'd say, well, you know what, you can do with that Canada Pension Plan retroactive. You can stick that up your fucking arse because I don't want it. But instead of that, they force us to apply. Then they approve people who do not qualify. Because did I mention that in the past? In order to get Canada Pension Plan disability, you have to have 4 to 6 years with recent contributions. I came close. I had 4 out of 7. But you know something? According to their letter of the 26th of July, 2013, they said, thank you for your application, Mr. Edward, but you don't qualify because you don't meet the minimum qualification period of 4 out of 6 years. So how did I get approved? How come the government is trying to make other veterans like Denis Ouellette, Captain Retired, in somewhere in Alberta, Cool Lake? He got out in 2004. They tried to make him apply in 2016. 12 years. 10 years too late. He couldn't get it legally. He's talking to me. He tells them to go fuck themselves. They cut him off. So that's what you get for rocking the boat. He couldn't get it legally. They had no right to make him apply. They had no right to make me apply. It wasn't Manulife in my case, it was Sun Life. But same thing, it's a government insured program that's administered by a private company to make it appear to be a private insurance. When it's not a private insurance, it's government insurance. They underwrite the policies. Dennis Manouche sued Her Majesty the Queen. He didn't sue Manulife. In the RCMP case, there was 2 cases going concurrently. They decided to only hear one case and settle both of the cases based on the one decision. So the RCMP case was called a Butte Estate, B-U-O-T-E estate, because the guy who was suing died. So his family kept the lawsuit going in his name. So it was the Butte Estate versus Her Majesty the Queen. So you had Dennis Manouz versus Her Majesty the Queen. You had the Butte Estate versus Her Majesty the Queen. And then they had the gall to tell me that none of these insurance plans are the government, first of all, and that the Sun Life policy, which covers unionized public servants, which I was in the union and I was part of that policy, that they are not the government. It's just like, if you're watching the Trump trial, which is a train wreck, so I've been watching a lot of it, it's like him saying, I didn't have sex with Stormy Daniels, I didn't have sex with this other lady, I can't remember her name, with. Everybody knows they did the nasty. So you're better off not making yourself a liar by telling people you didn't have sex with them when you had sex with them. Just say it happened. And then there's nobody that can infer that you are a fucking liar by denying it. Now the latest one in that fucking train wreck is he's saying that he never said lock up Hillary Clinton. Can you imagine if anybody's alive long enough to remember the news from back then and seeing that bastard getting on the way he's doing? He was always saying it. So you don't go on some news program in 2024 and claim you never did it. I think his mind is gone. I think he's gone insane. Because anybody who can look back at the records and look at the videos can see that he did it. So you shouldn't deny things that you do. Own up to it and move on. On that note, thanks for watching. And one of these days, the Office of the Veterans Ombudsman gave me a little bit of hint that it might actually, they can look into it. Because that's all I can ask for, okay? What I don't want to be told is not within our mandate. What they need to do is say, well, thank you for your report. We'll contact you if we need to in the future. And then I'm always saying, well, I would like to help, so get a hold of me at any time. But what I don't want to be doing is like the Canadian Forces Ombudsman last week. I've been on the phone arguing with you for 30 fucking minutes. She didn't use the word fucking, but 30 minutes. They're not getting paid to argue with people who call in to make complaints. It's awful cynical, but I've said it a dozen times, a million times probably. All they need to do, if they want to cover this up. Thanks for your call, Captain Retired Matt Edwards. We'll look into it. Now, they could throw that in the garbage, but I would hang up feeling that I did my part. I tried to get this fixed. Now, what they do about it is up to them, not me. Now, I might get curious a year or 6 months later and look into it, but I would hang up the phone and I would be happy at that moment. But by arguing with me, they make you suspicious, okay? If they hang up on you, they make you suspicious. They are government employees. They might work for the ombudsman, but they're public servants. They have to serve the public. They can't ignore things. They can't look the other way. I mean, the public has a right to be treated fairly. The public has a right to know about all this stuff. It's one thing to make a mistake, but it's how you deal with it that really matters. Make the mistake, like there was a general in Afghanistan going into a tent. He was clearing his pistol. The pistol went off, and then he reported himself for a negligent discharge. Now, I admire and respect people like that. He was in a theater of war. I mean, I think that was something that was minor and could have been overlooked. It wasn't like he was back in Canada. But he did the right thing and reported himself. Now, how many people would have the integrity to do that? See? Reminds me of when I made a mistake and I apologized to my commanding officer. I went to a medical. I had the time wrote down on a piece of paper, 8:30. I put into my Google Calendar, 9:30. I showed up at 9:30. The doctor was gone. I get called in on the carpet for the colonel, and he said, "You're trying to make me look bad. I told you 8:30, and I thought I was right. And I argued right back to him. He said, I got it wrote down here on this piece of paper, 8:30. I said, that only proves, sir, that you wrote it down, not that you told me. When I got home, I found a piece of paper where I had written it down, and I immediately emailed him and apologized. I called him and apologized, and I called the adjutant and apologized because I was wrong. Now, I could have covered that up. I could have ignored the fact that I wrote it down. But that's not how it's supposed to be. You got to look yourself in the mirror. I was wrong, so I'll admit it. That's the way they should be. But unfortunately, there are people out there that shouldn't be in uniform. That same adjutant I told you about, he called Sun Life on me. Tried to get me in trouble by calling a third party and telling them that I was working, serving in the military a couple days a month, and he wanted to get my benefits cut off. Well, Sun Life calls me. It didn't go the way they thought. When she called me and said, the Captain Sullivan tells us that you're working a few days a month with the military, and how come you never told us or something? I said, who told you? When did they call you? What was their authority to call you? Are you fucking forgetting that I signed a rehabilitation agreement with you guys back in August? And this is supposed to get me hardened up enough to get back to work for Canada Revenue Agency. Well, they backed down in a fucking hurry. Now later, when I was trying to settle things with the captain, I went and met with him in his office after a very stressful racket, that same thing that I was telling you about where the doctor's appointment was mixed up. I don't like trouble, no matter how much people might think I do. So I said to him, he was a captain and I'm a captain, I said, John, what really pisses me off here is that, you put my benefits in jeopardy, my wife, my kids, and myself. I'm getting long-term disability benefits, and if you had questions about that, because I told you about it on Thursday night last week, if you had questions about that, you could call me. You could have said, are you working right now? That's what he asked me, and I said, no, I'm on Sun Life disability. He could have said, well, how come you're serving here in the unit if you're too disabled to serve with Canada Revenue Agency? Then I could have said, well, I have a rehabilitation agreement where I'm trying to get a little bit of work each month until get me used to it. Until then, I can go back to full work with CRA full time. I could have told him that. But no, you called Sun Life and you tried to get me in trouble when you could have fixed this, looked into it with me directly. I never called Sun Life. Said that's not what Christine Rooney of Sun Life said, and I have an email from her as well. So, you call her. He leaned across the desk to me. And I'm surprised I never nailed a prick. So what if I did? He said. I was lucky to get out of that office without planking him between the two fucking eyes. Because basically he was so immoral, so crooked, that nobody was there. There was no recording. There was no tape. It was just him and me. And he told me I was right. But there was nothing I could do about it. If I went to someone and I said he admitted that he did it, he'd just deny it and say I'm lying. And it's hearsay. But what he didn't understand, because I am a legalistic type of person, I looked up the Canada Evidence Act, and there's a thing called an excited utterance that does ignore the hearsay rule, and that would have been, maybe anyway, permitted as real evidence, instead of just being that he said this and I said that, and therefore you can't believe either one because which one's right. But that's what I've been dealing with, that kind of shit. Instead of, when they knew that I was going to have to be medically released, they could have left me alone. They didn't have to torture me psychologically. Like, they never gave me an office, never gave me a phone. They told the other officers not to talk to me. None of that's right. What they ought to have done is just let me continue parading, going to my unit, serving until my medical release date comes. Nope. Now, I don't know why they do what they do, but there's a tribal type thing that sometimes people think that anybody is different from the other people. They get mobbed. That's one theory. Listen, talking too much. Thanks for watching. And I'm hoping that we get some of this solved one of these days. And I'm hoping some of it gets solved without a lawsuit.